out of the scope of industry. For instance, sovereign functions of the state cannot be included, although what such functions are has been aptly termed the primary and inalienable function of a constitutional government.
We need not to go into these. Because at that time, whatever the globally the jurisprudence was developing, that has been referred to. So you take note of that.
Yes.
Coming to the conclusions, John, and then would like to have your own notes here. Questions to.
No, I thought a little more reading. I'll conclude because it goes on how to iron out the creases and what is felt the absence of certain factors in the definition. And then the court says, what is the statute we are looking at? It is a worker welfare oriented statute. And therefore, the purpose of the act must be so fulfilled in order that I do not truncate the mission of the act. So while doing so, whether the court probably drew a line somewhere which continue activities would not be in the nature of an undertaking analogous to trade or business, and also while looking at functions which are now essentially what I may call constitutionally mandated public purpose activities, which are now drawn through different parts of a constitution. And most importantly, we say in the Schedule 7, your allocation of legislative functions and administrative, executive functions, you find a whole lot of them, which perhaps would not fit in with the old narrow concept of sovereign functions, inalienable, etc. For the concept of sovereign functions, even though it has been retained in the new code, it will receive its color from an entirely new conceptual way of understanding those, what I would call again repeatedly, constitutionally mandated fields of activities where the determination as to in what way I will exercise these activities, in what way I will pursue these activities, and in what manner, for the purpose of executing them, I will have a certain framework. It could be an establishment, it could be directly done, it could be indirectly done. Therefore, when we enter into that, to say that in paragraph 50, where I said the primary and inalienable functions of a constitutional government, we go back in point of time to what was originally in international law, sovereignty concept, and again between state and state, or we again fall back in the judgment I will read from Nagendra Rao, in the field of civil law, torts. We have moved far away from the act of state principle. Therefore, the state is liable for a wrong committed by a servant or an employer, but they are in the field of civil wrongs. But when we come to an entirely different domain of activities where in the exercise of its, I said, constitutionally dictated functions, whether you could probably truncate and confine, a cabin confine, as I may call it, the sovereign functions aspect and go back on very historically outdated understanding. That's why I thought I'll read paragraph 50. Yeah. Kindly turn to paragraph 51. I'll quickly read through some of them. I was 51. Although we are not concerned in this case with those categories of employees who particularly come under the department charged with the responsibility.
All these paragraphs are ultimately crystallized in
sorry.
paragraph 140, 141 onwards.
Correct. It crystallizes. I thought some plans.
Position on the conclusions of the judge bench.
I'll immediately come to that, but why I thought some paragraphs need to be read is what was the thought process which went into the mind of the court in saying what do you pick up from each one of the judgments? Do they have a connecting thread? Is there a connecting thread available in all these judgments? But ultimately, I find out what are those connecting threads which I can call out as principles for the determination or the definition of industry. So these are very important milestones with the court to cross.
Just highlight them, that's all.
140, paragraph 140 is actually connected.
I'll come to paragraph 140. Page 73. Page 73. Industry as defined in section 2J and explained in the wide report. So these are three principles with the court calls out from this decision as on their analysis. But then B, C, D, I think let us look at it. Absence of a profit motive or gainful objective is irrelevant. Be the venture in the public, joint, private, and other sector.
It may not be also. But they say there is.
Subpara C seemed to introduce a little nebulous, sure, and probably it dilutes the other three earlier parts. The true focus is functional and the desired test is the nature of the activity with special emphasis on the employer-employee relationships. Then the organization is a trade or business, it does not cease to be one because of philanthropy animating the undertaking. Then para 141. Although section 2J uses words of the widest amplitude in its two limbs, their meaning cannot be magnified to overreach itself. Then A, undertaking must suffer a contextual and associational shrinkage as explained in Banerjee. And so also I think there is, Banerjee perhaps does not go on the same wavelength as this. So also service, calling and the like. This yields the inference that all organized activity possessing the triple elements in one supra, although nature of business, may still be industry, provided the nature of the activity, namely the employer-employee basis, bears resemblance to what we find in trade or business. So do we have a magic test to do that? On the one hand, it says, well, yes, though triple test is equal. On the other hand, the court goes on to say, probably the employer-employee basis in every such activity beyond or even a trade, there will be some employer, some employee. So that seems to have brought in a greater emphasis and focus on this nature and the employer-employee basis, bears resemblance to what we find in trade and business. There can be today activities where this resemblance may be completely absent. But there is some employer-employee relationship. And there could be an organized activity. And this takes into the fold of industry undertaking callings and services, adventures analogous to their carrying on their trade of business. So in his anxiety to leave no room for any doubt, Krishnaya just goes on to say, adventures analogous to the carrying on of trade and business. So all features other than the methodology of carrying on the activity, namely the organizing, the cooperation between employer and employee, be dissimilar, it does not matter if on the employment terms there is analogy. So ultimately, this seems to be the fundamental premise or a thread which will inform any discussion even in future on what would be an industry, notwithstanding the departure in the new code. Now 142, application of these guidelines should not stop short of their logical reach by invocation of creeds, skulls, or inner sense of incongruity or outer sense of motivation for the resultant of the economic operations. The ideology of the Act being industrial peace, regulation, resolution of industrial disputes, employer and workman, the range of the statutory ideology must inform the reach of the statutory definition, nothing less, nothing more. The consequences are professions, clubs, educational institutions, cooperatives, research institutes, charitable projects, and other kindred adventures, if they fulfill the triple test listed in so and so, cannot be exempted from the scope of Section 2J. There's some kind of a circularity I find here because I said the employer-employee nature will be important, then even if the other three tests are not so important. So if in a restricted category of professions, clubs, cooperatives, and even gurukulas and little research labs may qualify for exemption if in simple ventures, substantially and going by the dominant nature criteria, substantively no employees are entertained, but in minimal matters, marginal employees are hired without destroying the non-employee character of the unit. I pause here for a minute. There have been cases where, under the Contract Labour Act, so that it's been alleged that employees, in order to avoid the Contract Labour Act implications and application, you employ just persons less than 10. So the Act does not apply. These are devices. Of course, those devices will always be identified and said they are illegal. So I don't know whether that will probably help us anywhere here. If in a pious or altruistic mission, many employ themselves free of a small honoraria like return mainly drawn by sharing in the purpose or cause such as lawyers volunteering run of legal services, clinical doctors serving on their spare hours in a free medical center, or ashramites working at the bidding of the holiness divinity or like central personality, and the services are supplied free on a nominal cost, and those who serve are not engaged for remuneration on the basis of master and servant relationship, then the institution is not an industry, even if stray servants, manual or technical, are hired. Such eleemosynary or like undertakings alone are exempt, not other generosity, compassion, development, passion, or project. Then the dominant nature test, where a complex of activities, some of which qualify for exemption, others not, involve employees in the total undertaking, some of whom are not workmen as in the University Delhi case, or some departments are not productive of goods and services. If isolated, even then, the predominant nature of the services and the integrated nature of the department is explained in the Corporation of Nagpur will be the two tests. The whole undertaking will be industry, although those who are not workmen, by definition, may not benefit by the status. I find in the Corporation of Nagpur, virtually every department, every activity of the Department of Corporation of Kanpur, including a taxation department, an administrative department, so on and so forth. So the sword falls very broadly. So I don't know whether the Corporation of Nagpur, as in the context of municipal services, which now undertake an entirely different hue and color, should still be a good law. Now, notwithstanding the previous clauses, sovereign function, strictly understood qualify for exemption, nor the welfare activities or economic adventures undertaken by government or statutory bodies. How do we really therefore say what is a welfare activity or the economic adventure? So they will not qualify. So even in the departments in discharging sovereign function, if there are units which are industries and they are substantially severable, then they can be considered to come with Section 2J. I have no serious disagreement with that question, provided a particular activity is essentially a trade, business, commerce, or industry within the core meaning of the Act. then constitutional and competently enacted legislative provisions may well remove from the scope of the Act categories which otherwise may be covered thereby. This is what the new code has done in the penultimate clause. So we conclude with the difference because Parliament, which has the commitment to the political nation to legislate promptly in vital areas like industry and trade and articulate the welfare expectation, has hardly intervened to restructure the rather clumsy, vaporous and a tall and dwarf definition or tidy up the scheme although, which means Section 2J as it then stood was a vaporous, clumsy and tall and dwarf definition. I think it will be a little adventurous on a part to say that even though it was clumsy, let us say, but then vaporous because you want to connect trade, business and undertaking. You want to connect and charitable activity.
2 lines below. The court was informed that a bill is in the offing.
Correct.
Right? Therefore, the court had to clear the doubts in present time.
I'm not disagreeing on that question. I'm not saying anything about that. I'm only saying that the court from Banerjee onwards, was laboring hard to find out if I can give some electable meanings which will satisfy the Anti-Exploitation Genius of the Industrial Disputes Act, the anti-exploitation threat, which runs entirely through this act. So if they're trying to find out what will be all those meanings which can be probably go into the understanding of industry, because the court finds it is clumsy, vaporous, and so on and so. Not that I'm happy with this, but of course, to a considerable extent, the definition has some vague elements. I was recently reading a piece of literature on there's a need for something not to be specified in some parts of law. Room for specificity. That comes because if you define too much, if you say too much on a particular word or an activity or a word or a meaning or a definition, then you stultify what exactly the law will operate. The organic, functional, operational parameters of a law should be left sufficiently wide enough. That's what they need for. We take the word in tort and vicarious liability and how it has evolved over a period of time. Then when even in this case on municipal sovereign function, the Australian judgment says, I don't want to use the word sovereign function. We go to the word regal and non-regal function. So you will find some word in English language. We have all these problems of every language. So how much of it can capture? So we have meanings which a word gathers over a period of time. Which meaning will be the most fittest meaning is always a job of both a legislature and the court. So I think this where it must stop. But I must read to your lordships also what Justice Beg and Justice Chandrachud has said. By and large, the judges, both the honorable judges, concur with Justice Krishna, yeah? And Justice Beg, just to add.
Justice Beg has broadly, by and large, you agree.
I want just invite Lord's attention to 2 or 3 paragraphs at page 77. Page 77, at that part of para 149 beginning from the previous page, line about 5 from the top. We have so to speak. My let me place my points of view now one after another. So Continue, Lord. Right.
Yes, please.
So we have, on behalf of the workers and the working class, rightly so, we hear that the Bangalore water supply is correct law, and that it should be applied expansively, notwithstanding the new code, and that sovereign functions must be read restrictively. That's one voice which will be heard. Then on behalf of the state bodies, I find there are 5-6 states which are here, where they're concerned with the forest department, irrigation department, etc., being declared industry and things like that. So on behalf of the states, the submission will be the triple test in BWS is wrong, and therefore sovereign function should be read expansively. Then you also have charitable institutions like Pinjarapol. I've got to take a lot of the Pinjarapol judgment with a lot of interest. So charitable institutions and research institutions, like many of them are here, like a space research, then ICMR. And here that they do not fulfill the triple test, and therefore the application of the triple test to them was too overbroad. So we have three facets of this. So I think as far as the union is concerned, that as I analyze more and more the triple test, the tests are the factors which are interpreting the definition of industry as proposed by Bangalore Water Supply are logically correct because you're picked up from various judgments, namely employer-employee, right? There must be a organized activity. There must be a production of goods and services. The footnote extent is logically correct, and it cannot be said it has an inherent logical fallacies. But nevertheless, the problem arises not in the question whether they're logically correct or not. Nevertheless, the application of these tests are factors. As proposed by the majority in the Bangalore water supply, I say has been probably is too overbroad. In BW itself, you will find it. And therefore, an indiscriminate application of it leading to a over-inclusion of activities within the ambit of industry is going to be problematic. And therefore, the court is now probably called upon to clarify the application of these tests and factors, especially in the context of activities carried on by the state and other municipal bodies. May continue.
How much time? Because we had petitioner side, we had fixed 4 hours. So 2.5 have gone. And
I'll conclude in an hour's time. I thought by placing this very broad proposition, many concerns.
They need not to read out now judgments and all these things.
Yes.
They can straight come to their points. Will 10-15 minutes be fine with you?
No, we have placed a written submission. All those judgments are there. I just need
able to sit in 10-15 minutes up there?
maximum. I try to conclude within an hour or so. I'll try to be as brief as possible.
Only. It's because in para 4 and 5
I understand that.
of our order of 16th February, we have fixed the timeline.
I understand.
We will request the parties to adhere to that. Thank you.